Hi, I'm Chadwick Schnee, a Pennsylvania attorney and the principal of Schnee Legal Services. My practice focuses on Pennsylvania law, and one of the areas where I see families struggling most is navigating the guardianship process. So today I want to talk about what guardianship actually is, what the law says about it, and when it may be the right option for someone you care about. Let's start with the basics. What is an incapacitated person under Pennsylvania law? Guardianship in Pennsylvania is governed by Title 20 of the Pennsylvania Consolidated Statutes, starting at Section 5501. And the starting point for any guardianship analysis is the legal definition of an incapacitated person. Under Pennsylvania law, an incapacitated person is an adult whose ability to receive and evaluate information and communicate decisions is so significantly impaired that they are partially or totally unable to manage their financial resources or meet their essential requirements for their physical health and safety. That definition is intentionally broad. It covers a wide range of situations. We're talking about someone with advanced Alzheimer's or another form of dementia, a person who has suffered a severe traumatic brain injury, an adult with a significant intellectual or developmental disability who is transitioning into adulthood without the capacity to manage their own affairs, someone experiencing a serious and prolonged psychiatric crisis that has left them unable to care for themselves. The common thread is this: the person cannot make meaningful decisions for themselves, and the consequences of that inability are serious. What guardianship is not? I want to be equally clear about what guardianship is not, because this is a misconception I see fairly often. Guardianship is not a mechanism for taking control of someone's life because their family disagrees with their choices. Pennsylvania courts take the rights of individuals seriously. Before a court will appoint a guardian, there must be clear and convincing evidence of incapacity, and the court must find that guardianship is necessary after considering whether there are less restrictive ways to address the problem. This is a real legal standard, not a formality. Courts apply it with care, and petitioners need to be prepared to meet it. The two types of guardianship in Pennsylvania law recognizes two distinct forms of guardianship, and a court can appoint one or both depending on what the person actually needs. The first is a guardian of the person. This is the guardian who makes decisions about the individual's personal welfare, where they live, what medical care they receive, what services and supports they need day to day. The second is a guardian of the estate, sometimes called a guardian of the property. This is the guardian who manages the individual's financial affairs, collecting income, paying bills, managing investments, filing tax returns, protecting assets. It is entirely possible for a court to appoint only one of these. If someone can manage their personal care but cannot handle their finances, a court may appoint only a guardian of the estate. The law is designed to match the intervention to the actual need, not to impose a one-size-fits-all solution. Limited versus plenary guardianship. This brings me to another critical distinction: limited versus plenary guardianship. Pennsylvania law strongly favors the least restrictive form of intervention. A limited guardian has authority only over specific areas where the person actually needs help. A plenary guardian, by contrast, has broad authority over the person's affairs. Full plenary guardianship is appropriate only when the evidence demonstrates that no lesser form of intervention will adequately protect the individual. This preference for limited guardianship is not just a procedural nicety. It reflects a fundamental recognition that incapacity is often partial, not total, and that preserving as much of a person's autonomy as possible is a genuine legal value in Pennsylvania, when guardianship may be the right answer. So when is guardianship actually the right tool? Common situations include an elderly parent with advanced dementia who can no longer manage medications, recognize family members, or make coherent decisions about where they live. An adult child with a significant intellectual disability who is aging out of the school system and entering adulthood without the capacity to manage their own affairs. A person who has suffered a severe brain injury and cannot meaningfully participate in decisions about their own treatment. A vulnerable adult who is being financially exploited and no other legal tool is available to intervene. In each of these situations, there is a genuine need for someone to have legal authority to act on the person's behalf, and there is no existing legal document like a power of attorney that provides that authority. Consider the alternatives first. Before concluding that guardianship is the only path, it is worth asking whether any less restrictive alternatives are available. Pennsylvania courts expect petitioners to have done this analysis, and I think it is the right approach regardless of what the law requires. A durable financial power of attorney allows a trusted person to manage someone's financial affairs, and it can remain valid even after the person loses capacity. A healthcare power of attorney does the same thing for medical decisions. A living will can provide guidance on end-of-life care without any court involvement at all. For individuals receiving Social Security, a representative payee can manage those funds without a formal guardianship proceeding. The critical limitation of all these tools is that the person must have had legal capacity when they signed them. If someone is already incapacitated and no documents are in place, guardianship through the courts may be the only available option. Why this matters: guardianship proceedings carry real consequences. A court is being asked to limit or remove an adult's fundamental legal rights. The procedural requirements exist to ensure that happens only when it is truly necessary, and only to the extent that it is necessary. Getting this right matters, both for the person you are trying to protect and for the family members who will be living with this decision for years to come. In my next video, I'm going to walk you through the actual procedural process for establishing a guardianship in Pennsylvania, how to file the petition, what the notice requirements look like, what happens at the hearing, and what your obligations are after a guardian is appointed. If you have questions about guardianship or want to discuss whether it may be appropriate for your situation, reach out to Schnee Legal Services. You can find us at schneelegal.com. Thanks for watching.